Facebook. Thank you for that, giving us 1 minute to get that up. Good afternoon. My name is Emily Belanger with the Louisiana State Bar Association, and welcome to our Law Talks virtual workshop series. This week is Lawyers and Libraries Week, and we'll be presenting a law talk every weekday at noon. Today's law talk is Interdictions, Guardianship, and Alternatives. We have attorney Melanie Bray with Disability Rights Louisiana presenting on this important topic. Next slide, please. Before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end if time permits and answered live. If you're watching at a library, you may walk up to the computer to ask or submit your question to the library staff. If you're watching via Zoom, please use the Q&A section. And if you're watching via Facebook, please submit questions in the comments section. Please remember that all comments are public and visible during and after the presentation. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal process, but cannot give advice on individual cases. Next slide, please. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator. The LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentations or materials were free of errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. Okay, and with that, I am very excited to hand over the presentation to Melanie Bray from Disability Rights Louisiana.
All right, thanks so much. Good afternoon, everybody. My name is Melanie. I'm the current legal director at Disability Rights Louisiana. I've been with the agency for, it'll be 9 years this year. We started legal status changes. Tell you just a little bit about disability rights. We are a organization, and we are the protection and advocacy agency for the state of Louisiana. We have been designated by federal revisions to them based upon some funding changes that we have received, like many individual organizations that receive federal funding. We've all had some changes and we have to make some adjustments, but primarily we represent individuals with disabilities, or we provide information to empower individuals with disabilities to be stronger self-advocates. Today, we're going to be talking about legal status changes. We're going to talk about when people are faced with a decision to change a legal status. We're going to talk about autonomy, the difference between capacity and competency. We're going to discuss interdictions and tutorships and what those mean. And then we're going to talk about what the less restrictive alternatives are to a legal status change. So legal status changes commonly will come up in a school setting. So when kids are reaching the age of 18, which is the age of majority, and then they, by law, change from a minor to a legal adult, frequently schools will raise the issue of possibly needing to consider a legal status change. So parents will be faced with some information and some decisions around that. Group homes may advise parents of children, again, approaching the age of 18, that they need to make a legal status change. Generally, by doctors or other professionals or members of the community, parents who have children with disabilities may be advised that they need to change the legal status as their children turn 18. Also, older adults. Families may be advised that they need to interdict aging people to be able to make decisions for them. And then individuals with mental illness. Families are often advised to seek an interdiction for their loved ones so that they can make decisions for them when individuals are in an acute mental health crisis. But there are often alternatives to a legal status change. So before we get to those, let's talk about what some of these terms mean that we're going to be talking about. So the first one is autonomy, right? Autonomy is kind of a really big concept. It's the capacity to make an informed, uncoerced decision for yourself, right? So it's an individual's ability to act on his or her own values and interests. So whenever you make a choice on your own behalf, pulling on knowledge that you have and the decision is yours, that's autonomy. The right to exercise control and authority over your person, that's autonomy. So some examples, right? If when your parents tell you you have to go to grandma's birthday party, technically that's a loss of autonomy if you're not the one making the decision to go see grandma for her birthday, but it's an acceptable loss of autonomy, right? You should see grandma for her birthday. Your boss tells you what your job duties are, right? That's someone else imposing upon you activities that you're going to engage in or things that you are or are not going to do. Technically, it's a loss of autonomy. But again, it's acceptable, at least to the extent that you want to keep your job. If I tell you what you're going to eat for lunch, also a loss of autonomy. It may or may not be acceptable, right? If I tell you we're serving lunch today, the option is turkey sandwiches, it could be an acceptable loss of autonomy just because that's the only available option. But if we're going into a restaurant and I order for you without consulting you, that's not really an acceptable loss of autonomy. If your partner tells you how to spend your money, that is a loss of autonomy, and that may not be acceptable. When someone else makes all of your decisions for you, regardless of what your thoughts are on the topic, it's a loss of autonomy. Some losses are more acceptable than others, but when we're talking about legal status changes and when it's necessary and appropriate, the idea of acceptable losses of autonomy needs to be considered, right? In Louisiana, there are two types of legal status changes, right? So what the legal status means is once you turn 18, your legal status becomes competent major, just as an operation of law. You've turned 18, you are now considered a competent major. A legal status change is anything that changes that status as competent major to incompetent, right? So a tutorship is a change in whether or not you're considered a competent major. There has been a change in the law last year, and there are now full and limited tutorships available. We'll talk about all of that in a little bit. And then interdictions. An interdiction is a loss of autonomy, and that is a legal status change. Both of these options remove an individual's autonomy and give the authority to make decisions and the decision-making over to another human. While in some instances it may be appropriate to change someone's legal status, not all cases are appropriate. And we're going to talk about some examples. But first, what about the bad decisions, right? Everybody has the right to make decisions that are bad or that are unpopular or are risky or are just mistakes. We all deserve that dignity of risk to make a decision, have it fall to pieces, turn out poorly, and then have the opportunity to learn from it and hopefully make a different or a better or at least a more informed decision into the future. I always give the example of for years, many, many years, I was a smoker. It was a very informed decision. I knew all of the risks. It was a risky decision. It was arguably a bad decision. It was arguably a pretty unpopular decision with anybody who was around me, but it was a decision that I continued to make. And I got to make that bad decision because I have autonomy. I learned over too much time that it was not a decision I wanted to continue to make, right? But I had to get there myself. It's the same thing for all of us. We all make bad decisions. We all make mistakes. We all do things and engage in activities that are risky behavior, right? Individuals with disabilities are no different. They deserve that dignity of risk to engage in those decisions that are bad or unpopular or risky, or to make mistakes and then have the opportunity to learn from them. Depriving an individual of the right to make those bad decisions deprives that individual the right to grow as a person. So that's an important thing to keep in mind. Everyone deserves that dignity of risk. So capacity and competency, these two terms are frequently used interchangeably, but they're not the same thing. So capacity is not a legal status on its own, right? Your legal status, again, is competent major. Capacity is a factor in determining competency. It's an individual's ability to make an informed decision, right? So you've taken in information, you weigh the pros and cons, you determine based upon the knowledge that you have and the information that you've learned, whether or not to make this decision or to make that decision or whatever the situation calls for, right? Keeping in mind that informed does not always equate to a good decision at the end. It can be informed and you can still choose to make a bad decision. Capacity ranges and it's very fluid. It can be better at some times than at others. I always use the example of sunsetter syndrome, right? Sunsetters is a form of, it lives within the realm of dementia and Alzheimer's, right? That individuals with sunsetters are very clear and have capacity early in the day. But then as the day goes on, they lose that capacity, only to wake up again the next morning having regained their capacity. So capacity is really a very individualized determination. It's difficult to measure for that reason. It's a determination that's typically made by a clinician, a medical professional, be it a doctor, psychologist, psychiatrist. It is diagnosis based, and because of that, it can be biased, right? It's frequently seen discussed in a psychological report. Keeping in mind also that an individual may be diagnosed with a developmental disability that does not automatically equate that they don't have capacity. Competent major, as we've discussed, is all adults, all people who once they turn 18 are competent majors just by process of law, automatic, right? There's a presumption of competency. So people are presumed competent the minute they turn 18. When this legal status changes, it goes from competent to incompetent. Competency is a determination that can only be made by a judge. Until a judge says that an individual is not competent, that individual retains that presumption of competency. It is an evidence-based determination. Capacity is a piece of that evidence. But also you need to be looking at the functional limitations, right? An individual's functional ability to thrive in their day-to-day life, in their ability to take care of themselves, perform the activities of daily living, things of that nature. Also, an individual may be found either competent or incompetent as to specific areas. It may not be just a generalized across the board finding, right? So an individual might be found incompetent as to their person, so their ability to make medical decisions. And a court may say, this person lacks competency to make medical decisions, so someone else needs to step in and help with that. Or maybe an individual just has no capacity to understand finances, right? So a court may determine that an individual is incompetent as to finances only. Or it could be even more narrowly tailored than that. An individual might be found incompetent to deal with a succession, for example. So if someone passed away and left an individual with a disability a house, for example, the individual with a disability may not understand that process. Hell, I don't understand that process. It's complicated, right? You got to find a realtor, you got to get an appraisal, there's a lot that goes into it. So a court might find that an individual with a disability lacks the capacity to understand the process and therefore determines the individual is incompetent as to the succession only. And then another individual can step in and help deal with that. And then the individual with the disability has retained their autonomy over all the rest of their decisions, except that little piece for the succession. And again, just because we make decisions, we might make bad decisions. We all get to make bad decisions. We all do make bad decisions. Individuals with disabilities are no different, right? So sometimes it might be necessary to change an individual's legal status from competent to incompetent. One of the ways that that can be possible is through a tutorship. In 2024, there were amendments to the tutorship law. They created a full and limited tutorship intended to function similarly to interdictions. It changed the language for who is appropriate to be placed under a permanent tutorship to include children with any disability, not just an intellectual disability. So for instance, an individual who, a child who has no intellectual disability, but maybe uses a wheelchair under the language of the law could be subject to a tutorship and losing their autonomy and their rights to make decisions. And it also clarified that a continuing tutorship is only terminated by the court. It lasts until the death of the child, essentially, unless the court takes action to terminate it. The code specifically says that a continuing tutorship is appropriate for a child who is between the ages of 15 and 18. So a child, right, who possesses less than 2/3 of the intellectual or adaptive functioning of a person the same age with average intellectual or adaptive functioning. That could include, like I said, any children with a disability. The effect of a permanent tutorship makes the individual a perpetual minor. So beyond the age 18, the individual does not become a competent major. That individual does not become an adult in the eyes of the law, at least. The individual is a perpetual minor. The rights that are impacted, the legal rights impacted, are the right to contract, the right to marry, the right to make medical decisions, own property, sign a lease. Currently, the voting law is silent on tutorships. So we advocate for individuals who are under a continuing or a permanent tutorship that if they want to vote, that they have the right to vote, because the law is silent, where it specifically says that individuals under an interdiction do not have the right to vote. It doesn't say anything about tutorship, so we advocate that they do. So, and for individuals under a tutorship, third parties, outside persons, would look to the tutor or the tutrix for the decisions. In this particular instance, there are different types of tutorships. We're talking about continuing tutorships. For a continuing tutorship, it will be the parent who is filed for the continuing tutorship. The issue is what happens when the parents are deceased, right? It's a problem because then there's legally no one available who can step in and take it over. A new person can't step in and assume responsibilities of a tutorship. So either the individual with a disability who's under the tutorship would have to move the court and ask the court to terminate the tutorship to give them back all of their rights, or another person would need to step in and file for an interdiction. Both of those are difficult. Interdictions are costly. Tutorships are costly. So here's my unpopular opinion. Continuing tutorships are completely unnecessary. The tools that parents need to protect kids already exist under the law, do not come with the legal hurdles that involved with obtaining a continuing tutorship, and do not come with the same financial price tag that a continuing tutorship does. For medical decisions, there's the medical consent law. For financial decisions, there's representative payee, special needs trust, able accounts, joint bank accounts. And we're going to talk about all of those options, the less restrictive options, in a little bit more thoroughly. But these options already exist in the law, and they're available for parents to help protect children moving from childhood into adulthood, right? So that they aren't making that leap completely without assistance. And for individuals who truly meet criteria for an interdiction is available and is arguably a more appropriate course of action for an individual who truly does not have the capacity to consistently make reasoned decisions, right? Because tutorships, like I mentioned, don't have that option for another person to take it over. And so it would come with a much higher price tag for a third individual to file for an interdiction. Whereas if an individual truly meets criteria for an interdiction and an interdiction is filed instead of a tutorship, and if the curator, curatrix passes away, another person can step in and request to be appointed the curator or the curatrix, and it doesn't come with the same financial burden that filing an initial interdiction does. And it also it allows for successor curator slash curatrixes to be named, presuming that they meet the qualifications and the criteria for the court. So we've talked a little bit about interdictions already, so let's talk about that a little bit more thoroughly. So a full interdiction, broken down from the law, is for individuals who are over the age of 18, who are unable to consistently make reasoned decisions regarding the care of the person and property. If it's for a limited interdiction, it's person or property. Or they're unable to communicate those decisions in a manner that is understandable by others. And they are unable to make those decisions due to an infirmity. So an infirmity must be a condition that's serious enough to cause a significant impairment on the exercise of judgment. So for example, though, Alzheimer's, right, would qualify. A diagnosis of a developmental disability alone does not qualify. Deafness does not qualify. Substance abuse may qualify, but advanced age alone without something else does not. A full interdiction is the most restrictive remedy that is available in the state of Louisiana. It's been described by our Supreme Court as a civil death. It is the most intrusive remedy, and it's often more sweeping in its effect than is necessary to protect the interests of the individual. For a full interdiction, all the legal rights are transferred to another person, right? So I want you to think about all the rights that you have like a bundle of sticks, right? So in that bundle, you have the right to contract, the right to marry, the right to accept or renounce a succession, sue or be sued. The right to vote is included in there. The right to drive, consent to medical treatment, leave the state without permission. All of those are legally binding decisions that are included in your stick bundle, right? But also included in your stick bundle is your right to decide who your friends are, what family you spend time with, who you associate with, whether or not you have a job, where you work, what you eat, what you watch on TV, what you wear on your body, whether or not you have sex, whether or not you attend school, whether or not you go to the movies, whether or not you get to eat cookies in your underwear watching Netflix. All of those are decisions that are included in your stick bundle, and all of those are taken and given to another human when a person is placed under a full interdiction. Frequently, it is not necessary to protect the interest of the individual to remove all of those stick bundles, right? But that's often the effect that full interdictions can have. And sometimes it's because people don't realize the broad sweeping effect that an interdiction will have. Other times it's from more nefarious reasons, right? But these are things that you need to consider when you're considering whether or not you need to look into this as an option for your loved one. A limited interdiction should be less intrusive than a full interdiction. The intention is for it to be less intrusive, right? We talked earlier about the removal of some rights versus other rights and person and property and finances. That's what the limited interdiction is intended to be for. The court confers only those powers that are required to protect the interests of the interdict to another person, right? And then the interdict retains all of the rest of their rights. The problem is that orders are generally written too broadly. And rather than, even though the title of it will say limited interdiction, in the language of the order, it actually functions the same way as a full interdiction. So again, if this is an option that you're considering, you just want to work with your attorney and make sure that it's very specific as to what rights are given away and what rights the individual gets to retain, what autonomy they get to maintain for themselves. The only rights that an individual under a full interdiction retains, regardless of what the order says, is the right to challenge the interdiction or to challenge the curator and to retain an attorney to do both of those things, right? Otherwise, an interdiction terminates at the death of the interdict. The death of the curator can also leave the interdict in that weird gray area where there's no person legally authorized to make decisions, and the court needs to appoint a new curator. It's easier to do that than it is for tutorship, which again, like I said, you can't appoint a non-parent for a continuing tutor. So it's a little bit easier, and there are other options when the interdict it's appropriate for the person to be under an interdiction. But it's still a step that needs to be done in order for a new person to be put in place. So a couple of things that are just important to note. Reason to decisions, again, I'm going to keep harping on this. Everybody has that dignity of risk. Risky and poor decisions are not sufficient reasons for an interdiction. Everyone has the right to make bad decisions. Unable to communicate. If the person can communicate in any form, whether it's verbal or not verbal, that they're not a proper candidate for an interdiction, right? If an individual relies on ASL, for example, just because other people in their life don't speak, don't communicate via ASL and can't understand, that's not a reason to have the individual interdicted. That's a reason to either learn ASL or to use an interpreter, right? So those are just some important considerations to keep in mind. In 2020 now, there was an amendment to interdiction law that passed supported decision-making, which we're going to talk about in a minute, but also amended the requirements that you have to go through before you can file for an interdiction, right? So it added a requirement that you have to try a less restrictive option. You have to try something that is less restrictive than an interdiction before you're asking the court to put an individual under an interdiction. You have to try it, and if it fails, you have to explain why it failed. If you didn't try it at all, you've got to tell the court why you didn't bother to try it at all, right? And again, there may be reasons, valid reasons, that an individual would meet criteria for an interdiction without testing out less restrictive alternatives. But it's a requirement in the law that it's tried and explained why it didn't work or why it wasn't tried. So let's talk about some alternatives, right? So for medical decisions, there's advanced directives and medical consent. For financial decisions, there are several options. And then for a combination of both of those decisions, we have what's known as a power of attorney, representation, and mandate is what it's called in Louisiana, because in Louisiana, we make up our own words for things, or there's supported decision-making. So let's talk first about medical decisions, right? The hierarchy of consent in the medical consent law exists. It's just there. It's here's the revised statute, here's where it is, here's the language from the law. It's just the law, right? So an individual, if they go to the doctor and the doctor says, Joe doesn't have the capacity to make this medical decision for himself, you could then look to this list. and you find the next person that falls in line on the hierarchy on the list. So you go down the list and, oh, there's parent at number 6. Parent can come in and say, I am Joe's parent. And if Joe lacks the capacity to be making that decision right now, I am here to step in and assist with that decision making. And by law, parent is able to do that. If you go all the way to the bottom here, points 11 and 12, this covers individuals that lack anybody else earlier on the list, right? So these are the individuals who are typically in an institutional setting, who are aging, who their family has passed away and they've never been married, they don't have kids, and they just don't have another person in their life that is able to step in and assist if they need assistance with making medical decisions, right? Now we have the interdisciplinary team. So that's the IDT team for any of you who have yourselves or loved ones who have provider agency with support coordinators through waiver systems or otherwise. Those humans can get together as a team and say, the doctor says that this medical procedure is necessary. Individual lacks the capacity to provide the consent for that. Therefore, we as a team have determined that it's necessary and appropriate because the doctor says, and so we give consent to move forward. Alternatively, worst case scenario, the doctor can always petition the court and say, court, this medical procedure is necessary. The individual isn't able to provide consent. There isn't anyone else available to provide consent. Will you give me the authorization to provide this medical care that is necessary? That's an extreme example that is typically only utilized. It is only utilized when there is no one else to make a decision. But it's just to show that there are alternatives, right? There are other alternatives to make sure that an individual's medical care will be provided in the event that they lose capacity to consent. Another good option is a healthcare directive. Now, this is something that I advocate for all humans all the time, everywhere. Everybody should have an advanced healthcare directive, especially if you have a medical condition that could necessitate in-depth care in the future. You want to have a document saying either identifying the human that you want to help make decisions when you're not able, or to at least provide your doctors with whatever critical information about your care that you want them to know. So for example, some individuals, due to religious reasons, don't ever want a blood transfusion. That should be in a healthcare directive, right? You just put it all in the document, you give it to your doctors, and your doctors just know. There's no question, there's no nothing in the future. If it came up, they just have the information. So that's always an option. So then we'll talk about financial decisions. So some alternatives, real easy, low-hanging fruit alternative is a joint bank account, right? No one knew how to balance a checkbook and manage a budget until they were either taught or they learned the hard way, right? Individuals with disabilities are no different. You can't expect people to just show up with a bank account one day and say, yep, I know exactly what I'm doing. They need help, right? They need support. They need that guidance, just as you would do with any child. So get that joint bank account. You can monitor the spending, you can monitor the income and the status of the bank account, make sure that bills are paid, things like that, while still allowing the individual with a disability to have the autonomy to participate in the process, to learn the process, and to figure out what that budget should look like moving forward. Involve the individual with discussions about budgets and bill pay, right? Make it an active thing. Use visual aids if it's helpful, use other tools if it's helpful, whatever it is, just involve the individuals so that they're aware of what's happening with their money and that they have an opportunity to provide that input. Otherwise, there's representative payee, able accounts, or special needs trusts. Representative payee is used for Social Security benefits only. It is a Social Security thing, right? So a rep payee is designated when Social Security receives info that the beneficiary is either legally incompetent or mentally or physically incapable of managing their benefit. The beneficiary can object to the appointment of the person or can ask for it to be a different person. There are a lot of rules that go along with it, but it's an option, right? An able account is a tax advantage savings account for individuals with disabilities and their families to use, right? So it gives you an opportunity to be able to put funds into an account that are not going to count against the individual to impact their eligibility for public benefits. Any money in an ABLE account does not count as income and will not impact their ability to retain their Medicaid, Social Security, Social Security benefits, or any other public benefit that they receive that has an income base to it. There is a plethora of information available on the ABLE National Resource Center's website, which I've provided here. DRLA is also able to answer questions and provide guidance on ABLE accounts, as is the ARC of Louisiana. A special needs trust. A special needs trust is typically not something that you would look into unless there was something of high dollar value or a larger sum of money, right? There are monetary limits that can go into an ABLE account. So a special needs trust would be for that succession, right? Grandma left you a house in her will. You need something to do with it. You could stick it into a special needs trust. Then it won't compromise, again, the individual's eligibility for public benefits. Or if you get a settlement from a lawsuit or something and you have a very large dollar amount, you can put it into a special needs trust. It both protects that money for the benefit of the individual with a disability, the beneficiary, and it also protects the individual so that they aren't found ineligible for their benefits. Because a special needs trust is a legal document that's created, it has to be created by an attorney. So there is a cost associated with it. But again, if you're looking at doing a special needs trust, it's because you're trying to deal with a very high dollar valued item or a larger sum of money. So these joint decisions, representation and mandate, it's also known as a power of attorney, again, Louisiana. A power of attorney does not take away the individual's autonomy to make their own decisions. It simply allows the individual to grant the authority to another human to make decisions for them, right? So you can have a power of attorney. I can have a power of attorney for my mom, right? I've granted the power of attorney to my mom. My mom can make decisions for me in the event that I'm not able to, or if I just want her to help me make these decisions, I can say, please go deal with the bank for me because it hurts my head talking to them and I don't understand it. That power of attorney authorizes my mom to be able to go do that on my behalf, right? But if my mom started doing nonsense things like shopping sprees on Amazon with my money in my bank account, I can always revoke that and take it back and say, okay, you've gone beyond what I've authorized you to do. I'm taking this authority back. It's no longer granted to you. So I retain the autonomy over my choices, over my decisions, and over whether or not the person I've granted the authority to gets to keep it, right? A power of attorney can be for any or all reason. It can be as broad and general or as narrowly tailored as the individual chooses it to be. I strongly suggest, because again, it is a legally binding document, that as simple as it might feel to go on the internet and have the internet create you one, talk to a lawyer. Have a lawyer draft one up for you. They're relatively straightforward, easy documents. Have a lawyer handle it so that it's created correctly, so that it's actually a valid document, and also that it does the things that you, as the individual who's granting the authority, wants it to do. Supported decision-making is the last alternative, big alternative we're going to talk about. So supported decision-making is just getting help from people that you trust when you need it, right? It is taking something that we all do and formally turning it into a law, basically, right? It's saying that the individual with the disability can enlist the assistance of whomever they feel comfortable with, whatever supporters they want to use to help them make decisions. And they get to determine what decisions, who gets to help them make, right? So if you think about anytime that you have called anybody in your life and said, hey, I'm thinking about doing this, what do you think? Or I need to buy a new car. hey, I know my brother just bought a new car. I should call him and ask him what his car buying process looked like and see if he can't give me some advice. Or anytime that you go and have anybody help you with file your taxes, all of that is supported decision making, right? You are making the decision with the support of other people, even if those other people are simply providing you with information and helping you understand a process. That's still supported decision making. And this formalized process gives individuals with disabilities the same support, the same right to that support, and it just makes it something that is recognized by others, right? In Louisiana, it's also known as the Dustin Gary Act, and that is for the namesake, Dustin Gary. So the supported decision-making agreement is simply a document that identifies who the supporters are and what type of decisions they're going to assist with. The individual with a disability can choose anything. It could be health, finances, living arrangements, vacation planning. They can help with social relationships, like just friends and friend issues that come up. It can be dealing with education. It can be dealing with employment. It can be about cooking. It can be grocery shop. It can be absolutely anything that the individual with a disability feels that they need help with. And they can identify whomever they know and trust that they want a part of that process. It empowers the individual with a disability to become a more active participant in their own decision making, right? And it gives third-party people something that they can tangibly look at and reference to understand, no, Joe is here because I want him here to help me with this decision, right? It also can allow for a release of information to be signed for whomever the supporters are. So like, for example, if I wanted my mom to help me with my medical decisions, my mom could sign a general release of information, giving her the authority to access my health information so that she can be a part of my doctor's appointments, or that she could talk to my doctor after the fact, or maybe get some records to review if she wasn't at the appointment, so that she can help me better understand what's going on by obtaining the same basis of information. So the benefits of supported decision-making have been really positive. Supported decision-making adopters have reported increases in pride, self-confidence, happiness. They're willing to try new experiences, taking greater control of their health, helping others, getting jobs, staying in jobs longer, because again, it empowers the individual to make the decisions with support, knowing that they have that help and support. Somebody's got their back. They have a very clearly defined lines of communication for who they can communicate with for each type of decision. So if this issue comes up, they know who to call. And it just helps people feel more confident in their own selves. There is a risk of abuse and neglect, just like with anything. But there was a pilot project that was launched in Massachusetts a number of years ago. And the findings of this pilot project were that the rates of abuse and neglect were reduced as compared to not supported decision-making agreements. So just individuals living their lives in the world. Because the individuals are choosing people that they know and trust to be their supporters, it reduces the risk of people who have bad intentions from inserting themselves into a situation that they haven't been asked to be a part of. So we have a few minutes left. I wanted to include some slides with some information about special education considerations, because it's always an important thing that comes up, talking about the transfer of rights when children turn 18. So under the IDEA, students with disabilities have education rights under FAPE, the Free Appropriate Public Education, the least restrictive environment. They have rights under discipline protections and procedural protections. When an individual reaches the age of majority, so 18, or is nearing the age of majority, the school must give notice to both the student and the parent, right? By operation of law, when the child turns 18, all the rights that are under the IDEA that were given to the parent are then transferred to the student, right? And then the school must notify the student and the parent of the transfer of those rights, what those rights are, and the fact that they are going to be transferring. Now, when a student with a disability who turns 18, the parents can still tell the school district that the student can't provide information, can't provide informed consent about the educational program, right? But the student has the right to dispute this. So parent can still say, no, you can't talk to Joey. He doesn't get to make decisions. Joey can step up and say, no, I think that I should make decisions. I want to be a part of this, right? And it gives the individual the opportunity to voice their own perspective and opinions. If the student does not object or dispute, the parent can retain the educational rights, meaning all Joey has to do is say, no, I still want my mom and dad involved. Mom and dad can continue to be involved, right? If Joey steps in and says, no, I don't want those people here anymore, then their parents can be legally excluded because Joey is now a competent major, right? So at the end of the day, the parent and the child just need to have a conversation and to need to have a communication about this so that everybody understands that this transfer of rights happens, and that if student still wants parents to be involved, all student has to do is say, I want my parents involved. And then the school can't exclude them because that is then the child's choice, right? And there are rules that each school district has to have in writing, and they have to provide written information to parents regarding the procedures around the transfer of rights. And then of course there's changes if there's, the continuing tutorship, or if the after the child turns 18 an interdiction is put into place, that'll impact how some of that process works. Yeah. But the IDEA requires school districts to assist special education students as they move from the school setting into life after school, right? That process of moving from a school setting into adulthood, so to speak, right? There are, excuse me, processes that the school should be participating in and including both the parents and the child for transition planning. There are also other resources that are available for the student and the parent to get involved with, such as LRS, Louisiana Rehabilitation Services. They can assist with finding jobs, job training, things of that nature. So there are a lot of other tools and resources that schools should be helping to connect parents and children to for this transition process, for what life looks like after school, after high school. I've included some resources here about supported decision-making. The ARC of Louisiana is a phenomenal resources for supported decision-making and other things. They have actually created an entire user manual, for lack of a better way to describe it, for supported decision-making, how it works, what it looks like. And they've also had a program where they're able to mentor individuals and their families through a supported decision-making process to creating a supported decision-making agreement, how to implement it, what it looks like, things like that. And that's all I have. I wanted to make sure I saved at least a little bit of time for any questions. It was a lot. I said a lot of things in a very small window.
Yes, thank you so much, Melanie. That was amazing. While we wait for questions, I just want to highlight a few additional resources that may be helpful if you have a legal question that was not addressed during this presentation, or you need help getting assistance. Can
Well,
you
I'll leave on this screen.
please? Next slide, please, Melanie.
Oh,
All good.
there we go.
Yes, awesome. Thank you. This is the flyer for the LSBA's Find Legal Help page, where you can access a continuum of services. It includes our attorney directory, the civil legal navigator, legal aid and pro bono organizations, the modest means directory, and self-help services. I'd like to call special attention to Louisiana Civil Legal Navigator. This is a great sort of diagnostic tool that helps you identify your legal issue and provides customized information, referrals to legal aid, and more. It is simple to use and will give you next steps specific to your issue and or your parish or location. You can also access free legal answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions and have attorneys answer those questions through the site. It is private and acts almost like an email exchange between the user and the attorney. Please note that users must meet certain income guidelines to use this program. Okay, so let's see if we have any questions. Okay. Someone would like to know if they can file a POA for their own child in order to be able to withdraw from an annuity.
Without getting too far into weeds of your specific situation, no. A power of attorney is no one can do that on someone else's behalf. That's something that the individual has to do, and it's not something that a minor can do, right? But as the parent, I don't know, now I'm going to say this without knowing how the annuity is set up. That's a thing that you should go look at specifically. But as the parent, parents have their natural tutors of their children, right? So you have authority over things for the child, but you should look into whatever the specific language for how the annuity was set up, to see if what it provides for, what is allowed under it. But yeah, only competent majors are able to give a power of attorney to someone else.
Okay, great. Thank you. Give it another couple seconds. I'm not seeing any more questions pop up. Let's see. No, doesn't seem to be any more questions. So I think we'll conclude here. Thank you so much, Melanie. This concludes our Law Talk workshop for today. Please save the date for our next Law Talk during Lawyers and Libraries Week. It'll be tomorrow at noon, and the topic is wills and estates planning. Thank you again, Melanie, for presenting this very important topic. All the information was so useful, and I hope everybody here today learned something from it. Thank you so much.
Thank you.
Bye.